Good morning, everyone. Thank you so much for being here for this Festschrift honoring the career and scholarship of Douglas Laycock. I'm going to start with just a few preliminaries and then turn it over to the star of the first 15 minutes, which is Dean Bobby Chesney from the University of Texas School of Law. A few logistical items first. I want to thank our donors that have made this possible. So the First Amendment Center that's hosting this is called the Bech-Loughlin First Amendment Center. Due to a number of generous donations from Doug Beck and Sam Loughlin. They also, incidentally, for those of you who are visiting from out of town, gave another donation to help completely rebuild the 1L wing of the law school, which you can reach just by going through this courtyard and through those doors. You might enjoy seeing that as well. There's a wonderful display of the history of the First Amendment Center and information about Doug and Sam as well. I also want to thank the people who are actually responsible for this, which I've had a number of people thanking me. I have done almost literally as close to nothing as a person could. I had a book launch 3 weeks ago. I've been doing a nonstop travel, and I haven't even had to worry about any of the logistics of this because we have a team of people who are so wonderful, and I want to make one of them incredibly uncomfortable. Sandra, would you please come up here? If you just came in, feel free to grab food, grab a seat. You're more than welcome. Wonderful. Sandra has been directing a team of people from across the university, undergraduates, IT folks, and others to make this thing happen. And as I say, I haven't even had to stress about one aspect of the logistical details because she is just so absolutely amazing. So Sandra, I wanted to give you a token of our appreciation and tell you thank you for everything you've done and for bringing everyone here. That has included pivoting multiple times this week because of a Category 4 hurricane bearing down on Florida and Georgia, which made it so some of our guests couldn't be here and are going to be joining via Zoom, and Sandra has made all that work seamlessly, so thank you so much.
Thank you. My pleasure.
Okay. Real quickly, I want to share one thing about Professor Laycock so we can get a sense of the man we're celebrating here today, and then I'll turn it over to Bobby. I'm going to share something that only Doug and I were aware of, that only I remember, because I guarantee he doesn't remember it. I have on my phone here an email exchange I had with him in 2008. So at the time, I took his religious liberty class on a whim. I didn't, like most people, I was enjoying all the benefits of religious liberty without actually knowing it was a field of study or any of the nuances of it, right? And I took the class on a whim and I just fell in love and I've been in the field ever since. But on April 18, 2008, Doug sent an email to me. It was then Professor Laycock sent an email to all of his students saying that the review session will be on 2 o'clock on Sunday. So this is right before finals. I emailed Doug and I said, the irony for me here is that I'm going to have to miss the review session because I never work on schoolwork on Sundays because of my religious beliefs. So remember, this is in religious liberty class. All we've been talking about are exemptions to free exercise exemptions, establishment clause, whatnot. So I sent him this email, and I said, as an aside, I actually find it kind of funny that this issue is coming up for me for the first time in my 9 years of higher education with this class. I also don't want to inconvenience the rest of the class or you by asking for any changes, but do you think it's possible to have someone record it? Doug responded within minutes. He said, I'm very sorry. The irony for me is that I have not encountered any law student observing the whole day before. Of course, the question doesn't come up that often. I'm sure I can still move this to Monday evening without attaching anyone's name to the reason for the move. And then he immediately sent out an email saying, everyone, we had a conflict that I didn't know about. We'll do the review session on Monday. And I thought, there's a man who's living what he's preaching. It was only years later that I found out he was an agnostic who couldn't possibly share my beliefs regarding the Sabbath day and yet still was so accommodating. So he's a man of integrity, and I'm grateful that we can spend the day here celebrating him and his research. So with that, I want to turn it over to Bobby Chesney to welcome everyone, and then we'll do some more things.
Well, I promise to be brief because I'm certainly not the star of this show. All of you are the stars of the show, but I'm really delighted that you're here. You get asked a lot when you're dean, why are you doing that job? What could possibly explain your interest in doing it? And part of the answer, at least for the one institution that I really know, which is the University of Texas, is it enables you to be aware of all the incredible intellectually enriching things that we do in our community. We're 141 years old at this particular school, and the accumulated weight of all the intellectual engagement and research and inquiry that's gone on before is quite something. But there are, like any mountain range, there are pinnacles on the mountain range. And that puts in mind things like Mount Rushmore. And if you were to try to construct what's the Mount Rushmore of the many talented scholars who have called this place home, well, we could debate that all day. There are many candidates in this room. But I think we'd have a consensus about a few people. And one of the consensus points would certainly be our friend Doug. No question about it. And as the bifurcated format of this Festschrift highlights, we might have to put him on twice. You get to, maybe we'll do bookends and we'll squeeze some other faces in between. And so it is with real pleasure to have the calendar ping me and remind me that, oh, it's one of those dean duties. Go open an event. Some more fun than others. This is very special, and it's made more special because many of you who traveled to be with us today, former colleagues, recent colleagues, people we know well and love, and others whom have not worked here, but we admire and know your work too. So to have you all in this space, in this community is meet and right, is a good and joyful thing to be in community to celebrate these ideas together. Doug, we're just proud to be associated with you, and I'm really proud to be able to be dean at a time when we're having this celebration of you. And so with that, I think Steve, do I turn it back to you? Yeah. Okay, I'll turn it back to Steve so we can open the actual engagement. Thank you.
Okay, so our first panel is going to be related to law and religion, and it's Tom Berg and Chris Lund. If they are, where Tom? There's Chris. There's Tom. If they want to come up, our moderator is Nathan Chapman. There's a third panelist who would have joined them but was unable to attend. He'll be submitting an article related to this. Nathan Chapman, because of the hurricane, could not be here in person, so he's going to be zooming in. I'm assuming someone who understands technology better than I do will make that happen. Well, there's Mark. He's there early, but he can listen. And there's Nathan. Nathan, welcome. Can you hear me okay? Waving, great. Nathan, I'll let you introduce our two panelists. I'm going to sit up here with them just to help the Q&A portion later, since it'll be harder for Nathan to see the room. But he'll be moderating, asking his own questions, and introducing our two panelists. So Nathan, I'll let you take it away.
Excellent. Thanks, Steve. Can everybody hear me okay?
Yes.
Great. So first, I need to thank Sandra and Steve for accommodating Hurricane Helene. I figured, given Doug's pretty strident objection to the Smith doctrine, that he wouldn't mind such an accommodation, even though it's not for religion. But Doug, since I'm not able to be there, I wanted to take sort of moderator's privilege to say now, thank you very much for modeling a kind of legal scholarship that is just filled with intellectual rigor, intellectual integrity, intellectual charity. Those are a combination of virtues that are unfortunately pretty rare these days. It's been a model for me since I've started. Thank you for your advocacy on behalf of people of virtually any religion, all religion, no religion, in an increasingly polarized situation. It's been amazing. And thank you, especially maybe for persuading me, making me rethink my own thoughts on some of these things. You kind of have a special gift of wielding Occam's razor with judiciousness and charity. So really honored to be a part of this. And now let me introduce the panelists. Chris Lund is the professor of law and Romano Stancroft research scholar at Wayne State University Law School. Tom Berg is the James L. Oberstar Professor of Law and Public Policy at the University of St. Thomas School of Law. And I don't know which order you all want to go in. It doesn't make a difference to me, but I'll hopefully be able to hear you. And then I have a couple of questions, and then we can open it up to the floor.
All right, that sounds good. I think I'm going to go first, if that's okay.
Great.
losing this name tag. First, again, I wanted to offer a quick and insufficient thanks to everyone who put this together. Rick Hassan and Sam Bray, who sort of got me to be part of it. They championed it, and then Dean Chesney and Steve and Sandra Garcia, who's been so wonderful with everything. The Law and Religion papers from this will be published in a 2025 edition of the Journal of Law and Religion. Unfortunately, life being what it is, there are a bunch of people who couldn't be here today, totally unrelated to the hurricane. Michael McConnell, Micah Schwartzman, Jesse Hill, and John Whitty. And then on top of that, with Hurricane Helene, we have Nathan Chapman and Mark Storsley who couldn't make it. So the panels are a little bit thin, but there's going to be a lot of people ultimately writing for the volume. A lot of people who really regret that they couldn't be here to celebrate Doug today. Most of the Law and Religion papers engage critically with Doug's work, but I wanted my prefatory remarks to sort of take this in a slightly different direction. Unlike most of the folks assembled here, I was a student of Doug's at Texas. I've known him throughout my career as a Law and Religion person, and I wanted to say something about him from that perspective. So this is going to be a bit of hagiography. I hope you'll allow that, and maybe it'll set the stage a little bit. There might be some things in here that the Remedies folks and other folks don't know. I think most of the stuff I'll say here today, the Law and Religion stuff, the Law and Religion people do know about. So let me say something first, which sort of illustrates the stature in the field. I have some slides. I'm going to try and make them work. I don't know who did that.
We should move to the side here.
Oh, excellent. Okay. And the clicker works too. All right. So in 1981, Doug wrote a piece in the Columbia Law Review arguing for a concept of church autonomy that courts had stumbled toward but not really recognized. And 30 years later, in 2011, Doug stood before the Supreme Court arguing Hosanna Tabor, this case about whether ministers could sue their churches for employment discrimination. It was the question of church autonomy in miniature, and he would win the case unanimously. It's a thing that few academics experience. I mean, rare enough that a scholarly idea of yours might be adopted by the Supreme Court, but also be the lawyer that was there that got them to it. Anyway, there's a paragraph from Doug's opening brief. In this paragraph, Doug is trying to convince the court that church autonomy is a real principle, that it has a real historical pedigree, that it comes from somewhere, that it wasn't just being made up on the fly. And here he is quoting from Justice Brennan's concurrence in Amos, which was probably the most developed conception of church autonomy from the Supreme Court at the time. And Doug is effectively saying to the Supreme Court, this idea of church autonomy isn't entirely new. Justice Brennan talked about churches having these rights of self-determination, including, as you'll notice, the right to choose their leaders, and he did this a long time ago. But let me draw your attention to the internal quotation omitted part of Doug's brief. It's in the red box. Justice Brennan here was citing something. He was quoting something. He got this idea of church autonomy from somewhere. Where did Justice Brennan get it from? So let me show you Justice Brennan's opinion in Amos. And here you have this line. This whole line is part of a block quote from Doug's 1981 Columbia Law Review piece. Justice Brennan, it turns out, got his ideas of church autonomy from Doug. Doug's piece is actually the first thing he cites Justice Brennan, even before the Supreme Court's own cases on the topic, which I found kind of curious. It would have been bad litigation strategy for Doug in his brief to point out that Justice Brennan had really gotten his ideas from Doug. Remember, Doug's arguing this case. And so we see this familiar line, internal quotation omitted. No, really, Supreme Court, church autonomy was your idea. All along. So I was a student here at Texas. I was a student of Doug's. I'm a proud alum of this law school. It was a particularly great time to be here if you were interested in church and state stuff. Larry Sager had just been recruited from NYU. Brian Leiter had yet to leave for Chicago, and there were a lot of other people in the building who knew and wrote in the area. I took 3 classes from Doug. I was his research assistant on his Remedies casebook, not that I know anything about that field. And I took an independent study with him, and the resulting paper helped launch my academic career. I remember Doug as a teacher. His lectures are exactly like his articles and his briefs. Clear, easy to follow, packed with information. It's like drinking from a fire hose from someone who had the inside story and who understood how all the pieces fit together. It was pretty rare for a law professor to really understand the whole world that surrounded their subject. At the time, law schools did not put much effort in teaching law students how to write. I imagine that's changed here. I hope it has. I learned legal writing from two people. I learned from my judge, Karen Nelson Moore, who was a law professor before she went on the bench. And I learned from Doug mostly from reading his articles. I caught on, even in law school, to the forcefulness of his writing. He wrote differently than other academics and lawyers. He said more in fewer words. He used metaphors that conveyed meaning without dumbing things down. He wrote simply, short sentences, simple words, technical jargon only when necessary, no passive voice, all the basic Strunk and White stuff. But I was a math major. I didn't know how to write anything coming into law school. Years later, I realized that other people too felt this way. My first conference, my first somewhat academic conference, was a CLE here at the University of Texas about religious liberty that Doug put together and asked me to come. I remember one of the panels was on the taxation of religious institutions. Doug was not on the panel. As I remember, there were practitioners discussing the IRS rules, restricting tax-exempt organizations from engaging in political campaigning. They got a question from the audience that they just didn't know how to handle. And after a couple people tried, Doug, who was in the audience, raised his hand and gave the correct answer. And I was sitting next to Mark Stern, who was then the general counsel for the American Jewish Committee. He was general counsel for the American Jewish Congress. Now he's at the American Jewish Committee. And he just leans over, I don't remember his exact words. He says, "This is the problem with having Doug at conferences. He can academic with all the academics, but he can also threaten to out-lawyer all the lawyers." Now, on the academic side, Doug's contributions to the field of religious liberty have been extensive. That's what the first half of this day is going to be about. He was the first to develop the idea of church autonomy, carefully distinguishing it from the idea of conscientious objection, which had then been the sort of dominant theory of religious exemptions. He teased out and analyzed the different conceptions of neutrality, that word neutrality, all these conceptions that often passed under the same label. He did the same thing later with the idea of church-state separation. These were analytical pieces that cleared up confusion, got people to stop speaking past each other. But they also came together in a powerful normative vision. Right? There are a lot of different conceptions of neutrality. There are a lot of different conceptions of separation. But this one, Doug said, this one is the most attractive. And this is the idea that he called substantive neutrality. The essence is essentially this, that no matter what the government does, it's going to have some influence on people's religious commitments. But the goal should be for the government to minimize its influence on people's religious choices. The government should try to do as best it can to minimize its influence on what people believe, or whether they go to church, or if they go to church, what church they choose, how those churches are run, how they're structured. All those things are for people to decide and not for the government. Substantive neutrality was institution independent. It wasn't really, not exactly a theory about the Constitution's meaning or about what courts should do. It was a theory of religious liberty in a liberal nation state. It did things, substantive neutrality did things. It offered, I think, the first genuinely powerful religion-neutral account of how religious exemptions could be squared with the equal funding of religious institutions. But I think even more fundamentally than that, it forced people to account for themselves, right? In a pluralistic society, religious liberty has to be defended in religion-neutral terms, right? We agree on religious liberty because we can't really agree on religion. And if our views on religious liberty are derived entirely from our views on religion, then the intractability of religious disputes means we're never going to be able to agree on religious liberty either, right? To go forward, we have to ground our visions of religious liberty in something else. We must defend religious liberty as liberty. That's the title of one of Doug's pieces. Steve quoted it last night, when we were at dinner. And in practical terms, Doug pushed the field to try to formulate principles of religious liberty that weren't pro-religion and they weren't anti-religion, right? They were principles that could have universal appeal. A lot of Doug's work is held up over time. I think it's still frustrating for me as an academic to think that I have a relatively novel idea and then discover that Doug said it better 30 years ago. On the free exercise side, Doug developed some of the strongest criticisms of the Supreme Court's decision in 1990 in Employment Division versus Smith, which cut back on religious exemptions, said religious exemptions weren't generally a matter of constitutional right. At the same time, ever the practical one, he developed a reading of Smith that maximized religious exemptions within Smith's framework, a reading that the Supreme Court's now adopted. On the Establishment Clause side, Doug's written a set of historical works warning the court off of overly narrow conceptions of the Establishment Clause. Those full conceptions are false. Their historical grounding is superficial. Doug's productivity is striking. His writings on religious liberty are published by Erdman's in a 5-volume set. Each volume is about 1,000 pages. The volumes, by the way, are good to have. A lot of Doug's work is not easy for the public to access, right? Doug has an important piece, suddenly timely again, about whether coercion should be a required element for Establishment Clause cases. It's in the Valparaiso Law Review, though, and for some reason I've never understood, that's not on Lexis or Westlaw. And the volumes also have all his editorials and his briefs, his book chapters, his political letters. You know, his resume is over there. It's astonishing. Anyway, consider the 5-volume set. And of course, it's striking because this is only one of his fields. Few scholars have had Doug's success at shaping the academic field of religious liberty. But of course, Doug also had a history in litigation. A lot of it, this too, has sort of gone under the radar, right? His brief to the Texas Supreme Court attacking the sort of bananas idea that Texas had to certify and credential religious seminaries. You know, it's incredibly illuminating, and it's written so clearly your parents could follow the argument. Doug's argued 5 cases in front of the Supreme Court. He tends to win or lose unanimously. I don't know what that means. 3 of them were unanimous victories. Lukumi, which established the Santeria's right to engage in animal sacrifice as part of their religious commitments. Hosanna Tabor, which established the immunity of religious organizations from employment discrimination claims brought by their ministers. And Holt versus Hobbs about the religious rights of a Muslim prisoner to wear a beard. You know, the fact that Doug, I think this unanimity is an important part of Doug's legacy. The fact that Doug kept Lukumi unanimous and kept Hosanna Tabor unanimous, I think it matters. Students read dissents. They get those in the classroom, but they don't read briefs and they don't read law review articles, and I think judges don't really either. So when the court's unanimous and there's no dissent, it has the effect of burying all the contrary arguments, and the court's decision ends up seeming obvious, maybe even incontrovertible. I'm not saying this is a good thing. There's something troubling about it too. But I think there's a heavy weight to unanimous decisions, and it means a lot that Doug kept Lukumi unanimous. Right? We tend to forget now that it was a controversial decision at the time, that the 11th Circuit upheld the city's ordinances, even though everyone now sort of sees those ordinances as flagrantly discriminations. We don't remember how mainstream organizations like the Humane Society came in on the government side, or how the United States Catholic Conference worked to stay neutral on the case, and how not even a single congressperson would sign an amicus brief supporting the Santeria. And Lukumi could have gone the other way. That's not how anyone will think about it, right? Not how the students or the scholars coming into the field will think about it. That's true for Hosanna Tabor too, although that's a little more controversial. For good or ill, I think good. The idea of church autonomy, the concept Doug developed as an untenured academic, is just part of the firmament now. And Hosanna Tabor, because it was unanimous, doesn't have the partisan valence of a 303 creative or an SFA or a Dobbs. Doug kept the whole court on board. Doug's briefs are as powerful as his academic writings. I really recommend them if you're starting out as a lawyer, if you're interested in law and religion. His ability to get to the bottom of the other side's arguments and expose the weaknesses in their foundation just really quickly. And I have a bunch of examples in my essay. I'm under time constraints. Let me just give you one. So, in Holt versus Hobbs, another case Doug argued, the issue is whether a Muslim prisoner could wear a half-inch beard. The magistrate judge had dismissed the claim on the grounds that his religious exercise hadn't been burdened enough. The magistrate judge pointed out that the prison had done a bunch of things for the prisoner, had given him a prayer rug, had allowed him Islamic literature, given him religiously compliant food. So what was this guy really complaining about? And this was Doug's response, right? One sentence. Summarizing the contrary argument, one sentence, responding to it. That is, because petitioner could obtain a pork-free diet and order religious materials, respondents could force him to violate his religious obligation to wear a beard. Presumably, this would work in reverse. If they let him grow his beard, maybe they could feed him pork every day. And that was just the end of a whole issue. Arkansas didn't respond to this. It just gave up on the sub-issue. I mean, 2 sentences. Doug didn't just argue 5 cases in the Supreme Court. His amicus briefs were frequently mentioned at oral argument. The court's logic sometimes tracked the amicus briefs in ways that are sort of obvious and a little bit embarrassing for the court for the lack of citation, right? His amicus brief in Newdow, the Pledge of Allegiance case, had sort of 4 factors that the court should consider, which show up as the 4 factors Justice O'Connor develops in her concurrence. There's no citation to Doug. His brief in Masterpiece Cake Shop with Tom Berg offered ways of thinking that clearly found a home in Justice Kennedy's majority opinion. And I think it means a lot that Doug did all this as an academic rather than as a professional advocate asserting a party line. You know, Doug argued Town of Greece versus Galloway in 2013, a case about legislative prayer. Crudely stated, and I'm being unfair here, I'm being deliberately inflammatory, but crudely stated, Doug's position was that the town's legislative prayers were too Christian. And if someone else had filed that brief or argued that case, it would have felt very different to the conservatives on the court, I think. But Doug had just been in the court the year before in Hosanna Tabor, right, arguing for the rights of the churches, right? He wasn't anti-religious, that just wasn't plausible. And then the next year when Doug comes back in front of the court arguing for the Muslim prisoner, for free exercise again in Holt versus Hobbs, the fact that he had just argued Town of Greece would have corroborated his bona fides once again. You know, in a polarized world, his constant crossing of the aisle, right, they not only helped clients in particular cases, but they helped shield the very concept of religious liberty from the corrosive forces of partisanship, which are all around us. And that, too, is a big part of Doug's legacy, maybe something to remember when we go home today. Thank you.
Thanks very much, Chris. Tom, whenever you're ready.
It's just a pleasure and an honor to be here. Thanks to Chris and Sam and Rick. Thank you to Sandra and Steve and everyone at the Beck Center. And Chris, thank you for that really great start, because I'm going to refer to some of the things that you said in talking about Doug's influence, but I'm going to drill down maybe into the ideas a little bit more. So you've been really comprehensive about Doug's amazing influence. So I've been teaching for about 30 years. Doug inspired me 35 years ago when I first thought about entering teaching. He continues to inspire me today with the model of what it's possible to do in this work. And I say theoretically possible to do in this work because almost no one has done or could do the kind of combination of effective scholarship and advocacy that Doug has done. I wrote in a smaller tribute about a dozen years ago that the Texas Law Review did, a tribute to Doug. They were giving him tributes a dozen years ago already, and I remember him writing, it's striking that they're sort of putting an end to my career here, or ruminating on my career a dozen years ago. The next year after that tribute to Doug's accomplishments, he argued and won unanimously Hosanna Tabor. So he was far from done. And all the other things that Chris has referred to. But I said then, and I would say again, I've had the chance to collaborate with Doug on articles and briefs over the years, particularly on protecting both the rights of LGBTQ people and the rights of religious objectors to same-sex marriage. And that has been the greatest privilege of my career, beyond a doubt. You've been my model in countless ways, ideas first and foremost, which I'll talk about in a minute. But as scholar and advocate, and combining those two distinct, sometimes conflicting or roles that are at least in tension, to do both of those at the level that Doug has done them is quite remarkable. And as Chris said, a writer who has somehow combines forcefulness and directness with nuance where nuance is necessary. I've never seen or heard anyone summarize a debate or a set of considerations on an issue the way Doug does. And of course, generously gives his time both to assist other scholarship and to assist people in groups in securing their rights. So thank you for all of that. So my focus in my paper for the Festschrift is on, I divide the 40 years that Doug has been working in the religion clause area into two periods with two central concerns in the debates over the religion clauses. And he has been towering in both of those periods. And I'm going to try to connect them. So the first period, running from about the 1980s to the mid or late 2000s, the central question was what value or what combination of values or order of values should underlie the two religion clauses, the free exercise clause and the establishment clause. Is religion to be treated essentially the same as other ideas and activities? Is it to be treated distinctively in some way? And if it's treated distinctively, the way the Constitution singles it out as a text, is the best metaphor for that, the best principle for that, separating religion from government, separation of church and state, or is it some distinctive concern with religious liberty? Is it some distinctive concern with religious choice? In that period, Doug's work was exceptionally influential in articulating those values and making the case, as Chris said, for one particular approach that actually brought together several different values. He was also particularly influential in defending religious exemptions from generally applicable laws, the Employment Division versus Smith issue. In scholarship and in practice through the Lukumi case, through his tireless work on behalf of the Religious Freedom Restoration Act, enacted in 1993. In defending them, he articulated this principle of substantive neutrality, where protections for religious freedom could be defended not on the basis that religion was a good thing that needed to be advanced by keeping it free, but rather there was a vision of neutrality towards religion that would also support the claim of religious liberty in exemption cases. In the past, accommodation of religion had often been argued by folks who said, we need religion in our society, and in order to preserve it, we need to exempt religion from the law. Doug's argument was quite different. We should protect religious freedom not because it's good, but because because religion is good, but because religion is a particularly important matter to the people that practice it, and that impositions on religious freedom cause serious human suffering. And that position, which he labeled substantive neutrality, also, as Chris described it, the point of substantive neutrality was not that religion should be treated neutrally in the sense that it's the same as other activities, but the government should treat religion neutrally in the sense that it should not be pushing people towards religion or preventing them from practice it, neither encourage nor discourage it, or at least minimize, as Chris said, the encouragement or the government's effect in encouraging or discouraging religious practice. That is, leave religion as much as possible to the decisions of individuals and the groups that they form. That position also reconciled neutrality, an important religion clause value, with choice, which is all and liberty, which have also been common throughout our tradition as central values. And so Doug's reconciliation of neutrality and liberty was a major contribution in that first period. In the second period, since about the late 2000s, I would say, and others would say, that the single most pressing problem in the area of the religion clauses has been that religious liberty became caught up in the general polarization of politics and culture. Indeed, religious liberty issues intensified that polarization and contributed to the cycle, so that one of the reasons why conservatives could say in 2016 that this was the Flight 93 election coming up, where you had to stop the plane from flying into the towers, was because the recognition of same-sex marriage was going to lead to impositions on religious organization, denials of tax exemptions, and so on. And similarly, the other way, religious issues cause intense resentment and fear on the left. And so religious liberty issues became a part of contributors to polarization. Paul Horowitz at the University of Alabama has called this the Hobby Lobby moment in religious liberty scholarship, right? This all crystallized around the case about the craft store chain that was denying fighting insurance coverage of contraception methods for women. And that really, among other things, along with the gay rights debate, really crystallized this idea that religious liberty issues were deeply polarizing and contributing to polarization, and in turn, polarization threatening religious liberty. If religious liberty is one side's issue only, or if each side manipulates religious liberty to favor the claims that they support and not the other side's claims, then it loses credibility as a protection for all, and that is for anyone. And again, Doug has been crucial in the last 15, 20 years on this issue, arguing for religious liberty for all and for protecting, for example, both same-sex couples and religious liberty. And that contribution has been absolutely crucial. So briefly, what is the relationship between these two periods? I worked this out in the paper, but I'll try to say quickly, how does Doug's work defining and defending religious liberty and substantive neutrality support the defense of religious liberty against the threats from polarization? Substantive neutrality, the idea that government should not be pushing people towards religion, but neither discouraging them, the focus on religious choice, gives vital resources for taking religious liberty seriously in a polarized society. This is, again, an idea that takes religious freedom seriously and protects it, but not as religious privilege. It protects religious freedom not as a matter of advancing religion itself or any particular religious idea, but as a matter of sympathy for the suffering that the believer faces. And Doug also connected this early on, even before these issues really became as inflamed as they had. He connected it to social conflict. I believe in the religious liberty piece from the mid-1990s that Chris cited, he said it is because the religious believer suffers, and we've seen this historically, that this is the case, particularly that they resist. We create martyrs, and we have social conflict as a result of that. So the connection between preventing individual suffering, that is at the heart of Doug's concern about religious liberty, also relates to reducing social conflict and at least calming polarization. And these are the purposes of religious liberty. These are among the core purposes of religious liberty. Substantive neutrality gives you that. It gives you an approach to taking religious liberty seriously without viewing this as a matter of privileging religion. But it doesn't give you a line for drawing the boundaries of how far religious liberty should go as against other interests. And that is inevitably central to the problems of polarization. What are the lines of religious liberty? What other interests do we have to take into account, and where exactly are those lines? So for that, I think there's another concept that Doug introduced in the same article in which he introduced substantive neutrality. He introduced a concept, or named a concept, or an argument that has not gotten as much attention, but is, I think, very important. He's talking about a case called Aguilar versus Felton from the mid-1980s. It was one of the Supreme Court's decisions that struck down any kind of aid going to parochial schools. It involved sending a program that sent public school teachers into private schools, including religious schools, to teach remedial courses in math, science, secular subjects. And the court, in a 5-4 decision, said, you can't do that because this would give aid to the religious mission of the school. Doug argued that Aguilar was wrong, and it has indeed been overturned shortly, a few years later by the court. He said, what we're missing here is you've got to compare the likelihood that teachers going into the schools will in some way teach religion or be affected by the religious atmosphere of the schools when they are public school teachers, after all. You have to compare that against what is the effect on the religious schools of denying them this, the ability to participate in this kind of program. Neutrality, in other words, has to be aggregated. It has to be looked on. The effects have to, on both sides, have to be looked at. Doug recognized that effects are complicated in a complicated world with lots of religious groups and lots of different government programs and possible effects. But over the years, through his careful and, again, trenchant kind of reasoning in his writing and in his briefs, he showed how you could do that, how you could take seriously the arguments of each side and make judgments as to whose interests were more severely compromised in a particular case. Aggregating neutrality, that is, looking at the effects both ways, is going to resolve questions about whether government is promoting religion or not. But it's not going to resolve questions where the conflict is between religious freedom or religious objections and other interests, including most prominently the interests of LGBTQ people in the same-sex marriage and other contexts. But I do think that Doug's method of looking at the effects on each side is central to his later work and to any kind of good later work attempting to take seriously the interests of both religious objectors and same-sex couples in our pluralistic society. It provides a model for how to, his notion of aggregating neutrality provides a model for considering how to protect both religious liberty and other rights in conflict. And we saw that same kind of careful, sympathetic attention to the interests of both sides in all of the work that Doug has done on same-sex marriage and religious liberty, which I've really been privileged to participate and collaborate with him. So my last point here in the article, and I can only begin to talk about this, is whether the majority on the Supreme Court is going to listen to any of this anymore. Interest balancing is, at least according to some of what some justices say, is the court shouldn't be doing this at all. I think of Justice Kavanaugh in the most recent gun rights case says we should be replacing any kind of interest balancing or taking account of the interest on either side with an approach focused on history and tradition. You're either doing history and tradition, or if you're not doing that, you're doing policy, and policy is bad. We first say, Doug has done history and tradition with the best of them in the religion clause area. He's written seminal articles on the original understanding and regulatory exemptions. He also made a powerful point at several different times in the debate over same-sex marriage and wedding vendors, objecting wedding vendors, which is that whatever you think about the line there, when a wedding vendor should be able to object to participating in a same-sex marriage, the exclusion of people from professions, from jobs, is a historic burden on religious liberty. The English establishment excluded Catholics from a whole variety of professions, and that is a kind of burden on religious liberty that, as a matter of history, we ought to at least take seriously. So I hope that the court in the future will pay attention to balancing of interest, to taking account in the most sympathetic way possible of the competing interests of conflicting parties in a case. I don't know whether the history and tradition approach will go in that direction, but it seems to me that it has to some extent. I'm not the only person to talk about this. Others writing about history and tradition are saying that. The scope of a tradition is not self-defining. In the latest gun rights case, Rahimi, we saw the court upheld the federal prohibition on gun possession by a person who is subject to a domestic violence order, and said that statute fits within the tradition of regulations of different kinds of regulations that have been allowed. But the previous regulations were not exactly like that. And the court said, well, they don't have to be exactly like that. Instead, you have to look at what are the principles behind the regulatory tradition. And the laws that have been traditionally present, that the court relied on, had the same focus. They restricted people who there had been some showing of physical violence by them in the past, and therefore you could that gave the government power to restrict their possession of or ownership of a gun. And on that basis, the court said the tradition applies here. So in deciding whether the tradition applies, you have to look at what the government's interests are and how they also affect the gun owners. So I do think that it's almost inevitable that the court will continue to have to continue to look at competing interests unless they want to take an extremely rigid approach to traditions. I certainly hope that they'll do that. Considering the interests of various sides in our polarized society is the only way forward in the long term. And more than anyone else, Doug Laycock has charted a way forward for us on that. And I hope we'll be reading him decades from now. Thanks.
Thank you, both Chris and Tom. I have a quick comment on the paper. The papers are both great, really valuable contributions, I think. I have a brief comment, and then I have a question. And then I'll open it up for questions for the folks in the room. So the comment is directed as much to Chris, I guess, as to Tom, more to Chris. There's a part of your essay, Chris, in which you say that Doug navigated the difficulties of transitioning from scholar to oral advocate before the Supreme Court deftly, making it sound like that might be a difficult thing. And my knee-jerk response to that was that I was much more likely to be sympathetic and pity the people on the other side of the aisle whenever Doug was arguing before the Supreme Court. He's sort of not just a hired gun for this one issue. He's like the architect to some extent who built the structure on which the court is trying to navigate. I think my sympathies lie more with the folks on the other side than with Doug trying to figure out the Supreme Court. I do have a question, and it's intended to be a little provocative, hopefully get some good discussion going. And this is for both of you. Does Doug have a constitutional theory, or a theory of constitutional law or a constitutional interpretation? His work has been pretty doggedly to argue for the court to be more activist in the field of religious liberty, to interfere more with the policy products of the ordinary political process. On what basis does he justify that activism? I think he has largely resisted the siren song of constitutional theory as an academic, and that there's probably a correlation between his success as an advocate and his disinterest in doing constitutional theory. But is there one that is identifiable underpinning his arguments about religious liberty? Is he I think he's pretty plainly not an originalist. Is he a Dworkinian? Is he sort of a liberal in the tradition of John Hart Ely and focused principally on protecting the interests of minorities? Is he a methodological pluralist? If the latter, is it a principled approach? And I think this gives rise to a question that he doesn't address a whole lot very directly, which is, a lot of liberals of his generation and subsequent generations have moved away from special protections for religious minorities on the grounds that, as a moral matter, religion isn't special. It shouldn't deserve special treatment. And he's not exactly wrestled with that question as directly as some of them probably would have liked. How does he decide? And is that related to his constitutional theory? So a lot of questions there, but I'm gonna let you have fun.
Yeah, this will be fun. That question's a great question. And with Doug in the room, we can all offer our thoughts first, and then Doug can actually say what he thinks. I do want to say something about the pitying the other side, your comment first, because I have a story there too. I think you know this, but I don't know if you do, that when you argued Holt versus Hobbes, you were arguing against Dave Curran, who was a graduate of this law school, and he was an articles editor with me on the Law Review, back in 2002. So, I knew Dave and his wife, and we were friends. And then Doug's arguing against him. He represented the Arkansas AG, and it was a terrible position for Dave for Dave to be in, because his arguments were really tough. And then there was this really embarrassing thing where the AG said some things that weren't true, and that got him in trouble too. But I remember talking to Dave after the case, and I was just like, well, what can you do? And Dave sat next to me in Doug's Remedies class. He knew what he was going to be up against. For
the record, David had nothing whatever to do with the perjured testimony in the brief.
Yeah.
He was embarrassed beyond words.
Yeah, he's a good guy. He's a good guy.
Well, you can say, we can all opine here that Doug is a methodological pluralist, I think, but in really the best sense. I think, Mark Gergen, you might have said this last night at dinner. I heard Doug is in sort of the best tradition of pragmatic legal reasoning. Text matters first. So in some cases, you will see Doug saying, look, as a textual matter, the position that is being argued here just simply does not fit with the text of the free exercise clause or whatever provision is involved. But history has done it carefully, done it with integrity. I would say doing it in sort of more of a purposivist way, the purposes behind a provision, rather than in sort of original meaning kind of originalism, but also understanding and how general purposes of a provision shade over into sort of general arguments about the nature of the system that the Constitution sets up, which is, in the case of individual rights, a system of with close attention to certain important rights. But that works back into text. You can't ignore the fact that the text of the First Amendment singles out religion in two clauses or two phrases in the same clause, and any provision that simply treats religion the same as other kinds of human activities and stops there is not taking account of the text of the First Amendment. Now, that does raise questions, Nathan, about how you order these different provisions. And those are questions that come up also for Philip Bobbitt, modalities of constitutional interpretation, that sort of approach, or Dick Fallon has talked about the different elements in interpretation. But it's also, I think, in the end, what the court comes back to doing, because even as they talk about tradition, they're going to be considering questions on the borderline of the tradition and have to bring in other factors as well. So we in the end, we end up being pluralists, or at least the court ends up being pluralists up to a significant point.
Yeah. Yeah, I would have said methodological pluralism, but also, I mean, sort of pragmatism in a way, that the court's methodologies are whatever the court's methodologies, and you're going to have to make arguments that the court is willing to accept, and so you're going to have to sort of follow the court on whatever its jurisprudential take is, and you're going to have to make arguments that they're willing to accept. So in a way, I mean, it's the pragmatism rather than the methodological pluralism. But I don't know what the relative weights are. I don't know what you would say, Doug. You want to correct us all?
Before Doug jumps in, do we have a microphone for him? You got one, great. And when folks in the room are speaking, it'd be great if we could run that to people so we can get it on the recording.
Is this on? Yes. Okay. Yeah, I mean, Tom and Nathan are right. I don't sweat theory much. And you do have to make arguments that fit with what the profession and the court will accept. I've said in various contexts, especially early in my career, that I'm a textualist. I didn't mean that the way the current right-wingers on the court mean it. Not the original understanding of the text, but the plain English understanding of the text. We are part of the audience they were writing for. Our understanding of that text counts as much as their understanding of that text. And even in the piece I wrote that emphasized that the most, I still said it's not only the text, and you also have to take account of the other kinds of things the legal system takes account of, and I've moved more and more to that position over the years. I think I'm not an originalist. I never have been. Originalism means we cannot learn from experience. After 250 years of working with the Constitution, we know a hell of a lot more about it than they did. But I do think history is relevant, history matters, and one of the techniques I've used repeatedly in my academic work is to say, what was the central abuse or the central problem they were trying to solve? And reading the text that doesn't reach that problem, really reading the text that doesn't center that problem, is not a very plausible reading of the text. So methodological pluralism probably gets me pretty well.
Great, thank you. And thanks for giving him a mic so I could hear. Yeah, I would have just summed it up in a very untheoretical way of saying that he's a really good constitutional lawyer. And if that's what a really good constitutional lawyer is, maybe that should tell us something about constitutional theory too. But why don't we open it up? And I can't see y'all, so this is a sort of very awkward form of moderating, but I'm gonna let Steve call on folks and I'm gonna watch.
Sounds great. And if someone else can run the mic, who would like to comment on or ask a question?
Thank you both for your presentations. And Nathan, it's good to see you on Zoom. One question I would be interested in hearing, maybe a little bit more from you, Doug, but that your comments brought up for me, Chris, was the journey along the way of the Hosanna DeBoer case. Because my recollection is that Beckett, who Doug was working with in that case, they wanted to argue that maybe ministerial exception was not a categorical protection, that it was more like strict scrutiny-ish. On the other hand, you had the government taking the pretty outrageous and, as we saw later, strategically blunder of a position that there's just no ministerial exception. It just doesn't exist. And Doug, characteristic of the way that he often does, came in a principled way and had a different approach than the one that the Supreme Court adopted. So I don't know if you have anything to add to that, Chris, or if Doug does, but I'm not, and I may not be remembering correctly, but I think that's a fascinating journey, how we ended up with the doctrine that we do for the ministerial exception, which is such an important part of the church autonomy.
Yeah, I don't know if I have the inside information that probably you do, and certainly Doug does. So Doug, you should just take this one. I wasn't at Beckett when this was okay.
Yeah, so there were a couple of big strategic choices in that argument, but the one Stephanie's asking about is could the plaintiff litigate about, could the court decide about pretext, right? Did you have to have a religious reason for discharging this person, or was it simply there's a narrow category of employees that are essential to the religious mission, and no second guessing. The church can fire them for any reason, including bad reasons. And there were folks at Beckett who said, we can't win on that second ground. It's too extreme. We've got to concede that you can litigate pretext. And my view was, if we concede that, the whole thing unravels, because every plaintiff will allege pretext, and they'll be able to point to some evidence, and every plaintiff will allege that you didn't really have a religious reason. And in the real world, religious reasons and secular reasons are going to be all mixed together. The employers have made a global judgment that this person can't fulfill the mission anymore. And so we've got to hold the line and say it's an absolute rule. It's not absolute at the margins in terms of deciding who's covered by it, who's a minister and who's not. But if you're a minister, it's an absolute rule. And a couple of these arguments within our group, I finally said, someone's got to make a final decision. I've got the most gray hair, and I'm the counsel of record. But for better, maybe it was risky, but anyhow, we got away with it. It's in the Roberts opinion that this doesn't have to be a religious reason. This isn't protecting particular reasons. It's protecting the church's decision-making process. So I think that's the one Stephanie had in mind.
Great. Other comments or questions?
Well, let me just say one quick thing about that. There has been a debate over the years about what is the nature of this ministerial exception that is now becoming more and more important as more and more employees are being called ministers, and the churches and religious organizations are protected against their suits. There is a sort of purely procedural understanding of the ministerial exception, articulated mostly by Chip Lupu and Bob Tuttle at George Washington, that it is solely the fact that the court is going to get into these questions about whether the church had a good reason for discharging the minister, or was it a pretext for an impermissible ground, and that will embroil the courts too much in second-guessing churches. If that's all that you have, then that's not necessarily going to provide a very solid foundation for the ministerial exception. What Doug has done is married that together with an emphasis on the substantive importance to the religious organization of being able to choose its leaders without government interference. So it's not just the involvement of courts in second guessing, it is the actual substantive decision. And so that may have been a pragmatic decision, but it's also fully theorized as well, which is, I think, an example of Doug's craft in doing both of those things simultaneously.
I have a question for Doug if no one else does.
There was a hand in the room, but you're the moderator, so you can overrule them if you want.
I would like to hear from the person in the room.
Okay.
So I think this question will connect both of y'all's really great talks on both the substantive neutrality point as well as the polarized society point. In a society that's very religious, substantive neutrality is, if you think of a spectrum between secularism and religiosity, substantive neutrality is more secular than a religious society. But as a society becomes more secular, then substantive neutrality flips to becoming more religious than the society. I'm wondering, as most demographic surveys show that America, like the rest of the world, is becoming increasingly secular. So I'd be interested to see what y'all think are the kind of implications of that conception that stays the same in a changing society.
So if we're concerned about how freedom of religion is going to not only protect against human suffering, but also reduce social conflict, then you have to come up with an overall approach in which freedom of religion is not a highly partial right that only protects one side. Doug confronted this in the 1990s in a piece, I guess the same piece really, arguing that the protections of the Free Exercise Clause could extend not only to atheists and agnostics, but also to a somewhat unspecified range of other more deeply held moral views. And I'm not sure I was ever completely convinced about where you were drawing the line there. But by the way, on atheists and agnostics, Doug made a point that is, I think, incontrovertible and that I continue to use whenever the question comes up, and that is the text of the First Amendment keeps you honest as to what counts as a religion. It says that because it uses the word only once in the text, whatever is protected under free exercise should also be protected under, restricted under the Establishment Clause or implicated in the Establishment Clause, because the word only appears once. A good textualist cannot play with the definition on both sides. So if atheism is not a religion, then the government is free to set up temples to the non-existence of God. It's free to have classes on the non-existence of God, and so on. And so an example of textualism in Doug's work. But so he argued more broadly that you have to extend protection to a broader range of moral views. Now, whether that works and how far that can work is a good question. The other thing, though, the other component of that is to develop and protect other constitutional rights that protect other interests, right? So that's where Doug's work on protecting both same-sex marriage and religious liberty is important. And we have both articulated, and again, he said the idea before I did, and I filled it out more, and then he's filled it out too, that there are parallels between the rights claimed by same-sex couples and the rights claimed by religious objectors in terms of a deep feature of identity that's lived out in conduct, and that conduct lived out in public, not just in private, in the closet or in the religious worship space. So, there's a coherence to protecting a wide range of constitutional rights, but the Free Exercise Clause alone is probably not going to do the work when society changes the way you're describing.
Yeah, I might frame it a little bit differently. I mean, I see substantive neutrality as a way to sort of bridge secular and religious components of a society. It is a secular concept in a sense, I think, that it's a secular justification for freedom of religion, but it only secular in a sense. I mean, I think that you could go back to a time in American history or, sort of world history where you sort of have a clash of salvationist beliefs. And I think, the substantive neutrality would work in that world as well, right? Where everyone has a religious conception, they're just opposing. It's a statement about what the state does and how the state can handle that clash. And I think it's a project that, is a lot of, is equivalent to a lot of like projects in political philosophy. I mean, I think like Rawls is doing that kind of, Rawls's project is about a clash of salvationist beliefs. Yeah. I mean, I think Doug, his work, parts of his work emphasize that religious communities are also going to have conversations within them about what religious liberty is. They're going to ground their conceptions of religious liberty maybe in their particular theologies. That's going to be inevitable. That's something they're going to need to do. I don't think Doug's work can't speak to that. But I think he acknowledges the legitimacy of those conversations.
Nathan, you want to bring us home?
Yeah. What time are we ending, Steve?
Now.
It's been a delight to be with you all, or virtually, and I'm really honored to be a part of this, Doug. Just no one is more deserving of this than you, and I'm so grateful for all the ways you've influenced me and that you've shaped this field and made it such a wonderful career to step into, and been such a great mentor to me in that process. So thank you, and thanks, Steve, for everything.
Thank you, Nathan.